You can.
Assalamualaikum. We are from Group 4 and my name is Effa Nabilah binti Masrom, and we are going to discuss about the treatment of the prisoners of war and Guantanamo Bay detention camp. First and foremost, as the introduction, I will briefly discuss about the prisoner of war. Prisoner of war is any person that have been captured or interned by a belligerent power during war in the armed forces, but a broader definition, it has also included guerrillas, civilians who take up arms against an enemy openly, or non-combatants associated with military forces. Next thing is the Guantanamo Bay detention camp, which also called as the GITMO, located in U.S. detention facility on the Guantanamo Bay naval base in southeastern Cuba. Gitmo was also used to house a Muslim militants and suspected territories captured by US forces in Afghanistan, Iraq, and elsewhere in the world. The facility became the focus of worldwide controversy over alleged violations of the legal rights of detainees under the Geneva Convention and accusations of torture, abusive treatment of detainees by US authorities. In early 2002, the camp began receiving suspected members of Al-Qaeda, which also the terrorist organization who were responsible for the September 11, 2001 attacks. Eventually, hundreds of prisoners from several countries were held at the camp without charge and without the legal means to challenge their detention. However, the camp was repeatedly condemned by the international human rights and humanitarian organizations, including the Amnesty International, Human Rights Watch, and ICRC, also by the EU and Organization of American States for alleged human rights violations, including the use of various forms of torture during the interrogations. In response to such criticism, the Bush administrations generally insisted that detainees were well cared for and none of the enhanced interrogation techniques employed on some prisoners were tortures. In 2009, however, the US official in charge of military commissions at Guantanamo declared that the detainee suspected as a would-be hijack in the attacks in September 11 could not be prosecuted because he had been tortured. Later on, in January 2009, Democratic President Barack Obama fulfilled a campaign pledge by ordering the closure of this facility at Guantanamo Bay within 1 year and a review of ways to transfer detainees to the US for imprisonment or trial. He also required interrogators to use only the technique contained in the US Army's Field Manual on Interrogation, none of which was considered torturous. The closure of Guantanamo camp was subsequently delayed by opposition from Republicans and some Democrats in Congress, who argued that housing the detainees in prisons on US soil would imperil national security. This basically has led more than half the camp's 166 detainees, some of whom had been cleared for and released or transferred, engaged in hunger strike to draw attention to their situation. Next, we move on to Naziha Husni, who will talk about the Geneva talks about prisoners of war.
Thank you, Effa Nabilah, for your previous briefly introduction about the POWs and also the Guantanamo Bay Detainee Center. So regarding to the POWs, we can see that there are so many international conventions that claim their protection for POWs. And the main is the Geneva Convention, Third Geneva Convention, 1929, that was signed at Geneva on July 27. It is official name, the Geneva Convention relative to the treatment of prisoner of war. and it's entered into force during 19 June 1931, and the version of the convention which cover the treatment of prisoner war during World War II, and it is also the predecessor of the Third Geneva Convention signed in 1949. Related to this convention, on the other side of the ICRC, International Committee of the Red Cross, stated that the provision actually concerning to the treatment of prisoner of war that contained in the Hague Regulation of 1899 and 1907 in the course of World War I, and they revealed the several deficiencies as well as lack of precision. Such defects were partly overcome by special agreements made between belligerents in Bern in 1917 and 1918. In 1921, the International Red Cross Conference held at Geneva expressed the wish that special convention of treatment of prisoner of war be adopted. Therefore, they existed this Third Geneva Convention. In this convention, there are um, 7 parts regarding to the treatment of prisoner of war, including for the hygiene, medical personnel, and also religious, discipline, and basic humanities right to be provided to the prisoner of war. If we if we talk about the treatment of prisoner of war, we can see that in the international level, even though there are so many international conventions that claim their protection to prisoner of war, we can see that in the warfare, in the armed conflict, there are not being treated well, as we can see that in the Guantanamo Bay in the US, we can see that they are also being tortured and there are persecution happen at the detainee center. And therefore, in my personal opinion, international convention, if we regarding to Geneva Convention or Hague Convention or even the ICRC, they cannot fulfill the humanities right for the prisoner of war. That's all from me.
Okay, next
Thank you.
on we move to the reason why detainees got detained by Faizatul Fazliyana.
Hi, and thank you, Effa and Naziha. So, when we talk about the reason why the detainees get detained, first of all, detainees is used to refer any person captured or otherwise detained by any armed force, and more generally, it means someone held in custody, and the prisoner in Guantanamo Bay are referred to the detainees. As for as for January 2002, around 779 men have been brought to Guantanamo, and nearly 200 were released by me by mid 2004. Before there had been any combatant status review tribunal to review whether the individual were rightfully held as enemy combatant. So approximately there are 50 nationalities were present at Guantanamo, which are Saudi Arabian, Yemen, Pakistan, Algeria, and Afghanistan. Although the Bush administration said most of the men had been captured fighting in Afghanistan, 2006 report prepared by the Center of Policy and Research at Seton Hall University Law School, reviewed by Department of Defense (DoD), the data for the remaining 517 men in 2005, which was established over 80% of the prisoners were captured not by American of the battlefield on the battlefield, but by the Pakistan and Afghanistan, which is often in the exchange of bounty payment. So the US widely distributed reflect the region and offer um, $5,000 per prisoner. And one of the example is the Adel Nouri, which is a Chinese Uyghur and descendant who had been sold to the US by Pakistan bounty hunter. And the Center for Policy and Research 2006 report based on the DOD released data found that most of the detainees were low level offenders who were not affiliated with organization on US terrorist list, and 8 men have died in the prison camp, and DOD has said that 6 were committed suicide. As for June 2013, 46 detainees were designed to be detained indefinitely because the government said that the prisoner were too dangerous to transfer and there was insufficient admissible evidence to try them. So that's all for me. We go to the Faris Izzuddin, sorry.
Next on, we move to Faris Izzuddin, who will talk about on how to deal with the detainees in Guantanamo Bay in perspective of human rights and humanity.
So in the perspective of how to dealing with the prisoner of in the Guantanamo Bay, the Geneva Convention confers a variety of protection to prisoner detained during an international conflict. Among them, protection relating to the human treatment. So the first one is according to Convention 3, Article 3, and also to Convention 4, Article 3, which in the next one is the interrogation, which according to Convention 3, Article 17, and also in Convention 4, Article 31. So the legal status of individual prisoner detected the scope of their protection under the convention. Nevertheless, all the persons detained in an armed conflict may be prosecuted for the war crime, the crime against humanity, and others. The crime also must be unrelated to the armed conflict. Similarly, all detained must be treated humanly and in accordance with the international human rights. And it also recommended by the ICRC. So to provide the context for the convention, the requirement of the human treatment, the Human Rights Watch explained that the torture and the ill treatment of the prisoner are prohibited by the customary law and also the international human rights treaties. The Article 7 of the International Covenant on Civil and Political Rights, which is ratified by United States in 1992, set forth the non-derigible principle that no one shall be subjected to torture or to cruel, inhuman or degrading treatment or punishment. Similarly, the Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment, to which US become party in 1994, which they also prohibited under all circumstances. So the third convention also extend to the additional protection to the prisoner of war. Under Article 17, prisoner of war are required only to disclose their last name, first name, rank, birth dates, and military serial number. Also, both prisoner of war and unprivileged combatant are protected by the convention. The general provision against torture, the Article 17, provide that POW who refuse to answer interrogation may not be treated, insult, and exposed to unpleasant or disadvantaged treatment of any kind. So move on to the Article 21. It also prohibited holding POW in close confinement except as necessary to safeguard to their health and in such of circumstances. The nature and duration of crime and also the confinement also must be limited to what it is necessary. Similarly, the Article 25 require that the POW must be accommodated in condition as favorable as to the provided for the force for detaining power and station in the same area. So moving to the Article 34, it also said that POW has a complete latitude in the enjoyment and exercise of their religious duty. Prisoners who are properly determined not to be the prisoner of war are not entitled to this and the other guarantees enumerated in the third convention. So generally speaking, that the prisoner of war may not be prosecuted or punished for mere participation in the armed conflict. Also, they may be tried for war crime, the crime against humanity, and crime related to the conflict. So according to Article 83 of the third convention, it is required that the detaining power that exercise the greatest leniency in determining whether the offence must be alleged to have been committed by prisoner of war be adjudged by judicial or disciplinary proceeding and provide that whenever possible the disciplinary rather than the judicial measure. So the Article 105 also said the correspondingly guarantees that prisoner of war the assistance of the legal defense by the qualified advocate or counsel of his choice. So it is further required that the detaining power must also present that the POW defense and ultimately oblige the detaining power to appoint a competent advocate or counsel if the prisoner of war does not choose their own. So in the light of this and the numerous other right and guarantee for the prisoner of war, it is clear that the Guantanamo Bay detainees are not being treated accordance with the third convention. Moreover, absent of objective in the determination to the legislations by the competent tribunal. So in the nature of their detention, it is we can see likely that the US has violated the requirement in the Article 5 that the detainees whose status is uncertain and also must be treated according to the third convention until their status is be determined by the law. Alright, that's all for me. Thank you.
Okay, move on to Aini Rabiha, who will discuss on the limitations of law that apply on prisoners of war.
Okay, thank you, Effa Nabilah. So, as been mentioned by my friend, which is Faris, Izzuddin, and Naziha just now, even though they have all the laws that abide to all the countries, but in Guantanamo Bay, it was provoked. And it was an unsuccessful investigation by the United Nations officials that shows the restrictions of law faced by the few organizations in ensuring human rights norms on Guantanamo Bay detainees. So, however, the first reason to the limitations of law is the United Nations itself is limited in its enforcement of human rights violations by permanent members of the Security Council, because every permanent member has a veto power. So, for example, it is well known that there are many alleged human rights violation in the China and also the Russia, but yet no United Nations action has successfully investigated or been enforced by to the human rights norms in those nations. Because it is because of they are the both permanent members of the United Nations and they also possess the veto power. Similarly, it is because the United States also retain as the veto power over any action by the United Nations, and any enforcement of human rights norms on the United States will never be permitted. So the second reason of the limitation of law is the United States claim that the IACHR, which is the Inter-American Commission of the Human Rights, which is to promote and to ensure the human rights in the American hemisphere, did not have the appropriate jurisdiction to adopt the precautionary measures. So additionally, the United States government has not provided any subsequent information to this commission, and for them to demonstrate that the United States was in the compliance with these precautionary measures. When the IACHR been asked the United States to conduct an impartial and also to conduct the thorough investigation into all the instances of the torture and other cruel, inhuman or degrading the treatment, and to prosecute and punish those responsible against, the United States has failed to respond. So, being a part of the various efforts to the enforce human rights norms at the Guantanamo facility have been largely what we call it, it is unsuccessful. So the United States has seemingly exercised its hegemony once again and more corrosively than ever in the international human rights regime. So indefinite detention at Guantanamo as well as the other human rights violation has shown the international community the ambiguities and the lack within the human rights regime. Unfortunately, the human rights treaty bodies have no real power to enforce the norms of human rights because they have no mechanism to force with the compliance. So the United Nations is really no different, similarly to the treaty bodies, which is proceed slowly and with inadequate resources and also no effective procedure mechanism have been established to deal systematically with the derogations. So lastly, we also see from the United Nations also unable to enforce its recommendation upon the United States. It can only continue to bring their recommendation to the attention of the United States. But for example, United Nations Office of the High Commissioner on Human Rights they issued another report in November 2014, which is comply with the repetition statements made in prior reports and condemn how the United States continues to deal with the detainees at the Guantanamo facility. So the report shows the report from the reports from the issue shows that there has not been much impact or change from the preceding report. So basically, all the reasons above, we could see how ineffective an organization is of because all of them depending upon the United States. That was the limitation of law regarding to the treatment of the detainees in the Guantanamo Bay. So that's all from me. Thank you.
Next on from Nabila Sahira, she will discuss on the cases that happened in Guantanamo Bay.
Okay, thank you, Effa Nabilah. So there were two cases to show the situation of Guantanamo Bay detention camp. So first case, the case on Shakir Ahmed, who is a Saudi citizen, had detained more than 13 years without trial. The case when US military joint task force Guantanamo believed that Ahmed had led the unit of fighters in Afghanistan, while his family was paid with a lot of money by Osama bin Laden. However, Ahmed denies being involved in terrorist activity. In Guantanamo camp, Ahmed as a spokesman for other detainees. He has raised the welfare of prisoners, negotiate with the camp commanders, and also he organized the protests against cruel treatment. He demands the prisoners to be treated according to the Geneva Convention. Ahmed said that he was being tortured, like be beaten for hours, and at the same day, there is 3 fellow prisoners died. The US claimed that this death due to the suicide. However, a law professor named Scott Horton claimed that the death was due to the torture rather than suicide. So Ahmed was released in 2015 due to the no evidence for his accusation. But still, it took a decade for him to release since there is no trial for him. So other case was Adnan Farhan Abdul Latif, who is Yemeni citizen. Latif was involved in car accident and he was suffered with serious head injuries which left him with a neurological problem. Latif said that he traveled from Yemen to Pakistan to seek medical treatment, while the US government accused him that he went there to receive military training for associate of Al-Qaeda. So he was captured at Pakistan and Afghanistan border and brought to Guantanamo prison. So immediately after his imprisonment, Latif January were blocked from filing habeas corpus. We know that habeas corpus is a report for unlawful detentions. However, President Bush policy at that time stated that the war on terror detainees were not covered by the Geneva Convention, so there's no trial. So in the camp, Latif was suffered with seizures and was not being properly treated because he was injured due to the accident. Other detainees trying to help by asking the medical treatment, but still that is unsuccessful. So Latif have released as the government had failed to show the evidence that he was part of the Al-Qaeda. However, he found that later. So Latif was suffered from imprisonment about 10 years without any trial. So these both cases show how detainees being treated and the struggle of detainees to against the accusation to prove they were not guilty. So that's all for me.
Thank you, Nabila. So to conclude this discussion, we will move to Aiman Quyyum.
Thank you, Effa Nabilah. So as for conclusion, based on my fellow panels just now have been discussed, this Guantanamo Bay, the US government secretly used the GB naval base for its selected prisoners. The treatment of prisoners at Guantanamo Bay was very humiliating and had no moral claim, which it shows that all the prisoners' senses were blocked, their eyes were completely blindfolded, and the nose and ears were muffled. The prisoners could not see, hear, smell, or feel anything. They were kept in solitary confinements. It was a secluded prison, and so the prisoners were denied any facility as per the international treaties. From the side of Amnesty International, they collected information on the condition of the prisoners in Guantanamo Bay and reported that the prisoners were being tortured in ways that violated the US laws. And also, they were being denied the treatment that even prisoners of war must get as per international treaties. Many prisoners had tried protesting against this condition by going a hunger strike, but then it does not give any good result for them, and they being keep tortured by the prison. And the prisoners were not released even after they were officially declared not guilty. Based on my friend just now, Nabila Sahira has stated regarding the case of Amir Shakir. Based on Amir Shakir, Amir has never been charged with any wrongdoing, was never on trial, and his lawyer says he is totally innocent. He was approved for transfer to Saudi Arabia by the Bush administration in 2007 and the Obama administration in 2009. He has been described as a charismatic leader who spoke up and fought for the right of fellow prisoners. This shows that after almost 1.5 decades, he been released after never did any wrongdoing, been charged with any wrongdoing. So what I can see for the first phase is that this Guantanamo Bay did violate the human rights of the prisoner of war. As I take from the statement from ICRC, prisoner of war must be treated humanly in all circumstances. They are protected against any act of violence as well as against intimidation, insults, and public curiosity. IHL also defines minimum conditions of detention covering such issues as accommodation, food, clothing, hygiene, and medical care. Based on the Article 13 of Geneva Convention, which stated by my friend Faris Izzuddin just now, it just states that POWs must at all times be humanly treated. Any unlawful act or omission by the country under whose captivity the POW is in, which leads to death and seriously endangers the health of prisoner of war in its custody is prohibited. Also stated by the RCRC, prisoner of war cannot be prosecuted for taking a direct part in hostilities. Their detention is not a form of punishment, but only aims in order to prevent further participation in the conflict. They must be released and repatriated without delay after the end of hostilities. The detaining power may be prosecuted them for possible war crimes, but not for acts of violence that are lawful under HL. This shows that if we take back the case of Shakir Amir just now, it directly shows that Guantanamo Bay does violate the human rights of prisoner of war. Also, I did take some of the statement by organization, also some of the leaders of the world, European Union, EU members, and the Organization of American States, as well as non-governmental organizations such as Amnesty International and Human Rights Watch, have protested the legal status and physical condition of detainees at Guantanamo. The human rights organization Human Rights Watch has criticized the Bush administration over this designation in its 2003 World Report, stating that Washington has ignored human rights standards in its own treatment of terrorism suspects. It has refused to apply the Geneva Convention to the prisoners of war from Afghanistan and has misused the designation of illegal combatant in order to apply to criminal suspects on US soil. The second one is European leaders have also voiced their opposition to the internment center. On 13 January 2006, German Chancellor Angela Merkel criticized the US detention of prisoners at Guantanamo Bay. And the last one I bring today, there has also been significant criticism from Arab leaders, which is on 6 May 2005, prominent Kuwaiti parliamentarian Walid al-Tabtabi demanded that US President Bush uncover what is going on inside Guantanamo, allow family visit to the hundreds of Muslim detainees there, and allow an independent investigation of detention condition. So, as for conclusion, what I can say from my personal opinion, this Guantanamo Bay prison, this Guantanamo Bay detention camp did not follow the treatment of the POWs rights, which they have been violate a lot of human rights in there. So, based on my last point, should future detainees be sent to Guantanamo Bay? Sending new detainees to Guantanamo would compound the detention facility's history of injustice and might repeat past violations of international law. Doing so will also be counterproductive to US counterterrorism efforts by providing fuel to the Islamic State, Al-Qaeda, and other Islamist armed groups that are seeking to discredit the US. Such armed groups have routinely used the situation at Guantanamo in their propaganda materials in order to recruit fighters globally. For instance, many non-Iraqis who took up arms against the US in Iraq did so because of US abuses at Guantanamo as well as the US military prison at Abu Ghraib. Sending future detainees to Guantanamo is also unnecessary. The US has other options for holding those apprehended and accused of alleged crimes committed abroad. So I guess that's all from me for this discussion. So I give back my stage to Effa Nabilah. Thank you.
Okay, thank you all. And that is all for the discussion from us. Bye-bye.
Thank you. Assalamualaikum.
Assalamualaikum.